As we go through, we will see what we have seen. We have seen the what brought this act to be, which is the erstwhile CRBC. What this act has brought to be. Thereafter, we have seen the territorial subdivisions. Territorial subdivisions. Thereafter, we have seen what the structure of criminal code, the hierarchy of criminal code. Then what we have seen the executive magistrates power. What are the executive magistrates and what are their powers? Executive magistrate deals with what? Prohibitory offences. Again, he cannot send a person to jail because he is not a judicial officer. He cannot punish anyone with fine or jail. Now, he can only give fine if his orders are not complied with. Then only he can give fine. Direct for the first time, he cannot give fine on conviction or something like that. He only takes bond for keeping peace and tranquility. Okay? Because he's an administrative officer. Then we came to the prosecution, the Directorate of Prosecution. Who are the public prosecutors? Who are the additional public prosecutors? Who are the assistant public prosecutors? How are they appointed? What are their powers? Okay? Therefore, we have seen the Directorate of Prosecution, which is the head of the prosecution. So it is the public prosecutor who distributes the brief, the allocation. He is the most important person. The public prosecutor of High Court is actually the public prosecutor of the state of West Bengal. The public prosecutor of Alipur Court is actually the public prosecutor of the district of South 24 Parganas. So wherever the headquarters is, the headquarters. The highest court of the state of the country is the Supreme Court. The second highest court of the country is the High Court. We have seen all this. We have already studied all this. High Court, then the district and sessions judge. Then you come to the Court of Judicial Magistrate first class. Second class judicial magistrate almost does not exist in the country anymore. Then comes the powers of the magistrate, judicial magistrate. We know that the chief judicial magistrate and the ACJM has the same power. They have the power to give sentence up to 7 years. Okay? 7 years. ACJM also has the power to give sentence up to 7 years. Now, the question is, what is the amount of punishment as a fine that the CJM of the ACJM gives? The CJM or the ACJM gives. What are the fine? See the book, powers of the magistrate, and then tell me what are the it can give. How much fine can a CJM order? See the powers of the magistrate. Sentences which magistrate may pass.
First class magistrate, a court of the magistrate of first class.
First class, what about CJM? See, tell me. Tell me, according to you, after reading section 22, what makes you suggest that what is the amount of fine, maximum amount of fine that a chief judicial magistrate can pass? Tell me. Judicial magistrate of the first class can pass up to 50,000 as per the BNSS. Erstwhile CRPC was only 10,000. Now tell me, what do you think that a chief judicial magistrate can pass? Fine, the amount of fine. From where did you get that? Where did you get that? See, the Code of Chief 23. The Code of Chief Judicial Magistrate may pass any sentence authorized by law, except a sentence of death or imprisonment for life, or of imprisonment for a term exceeding 7 years. He cannot give. So, what is the maximum that sentence he can give? 7 years. Next, the Court of a Magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years, or of fine not exceeding 50,000 rupees, or of both, or of community service. That has not been mentioned. The fine has not been mentioned in the clause 1 of 23. That means a Chief Judicial Magistrate limitless fine can pass. We will now come to the procedures and powers of the police. Open section 30. Police officer superior in rank to an officer in charge of a police station may exercise the same powers. Police officers superior in rank to an officer in charge of a police station may exercise the same powers throughout the local area to which they are appointed, as may be exercised by such officer within the limits of the office station. For example, suppose this is police station A. The OC or the IC, as the case may be, is the head of that entire jurisdiction of police station A. He is the head. Above him is the SDPO, subdivisional police officer. Above him is the SDPO. Above him is the SDPO. Because above the SDPO, who comes above the SDPO? I'm telling you that it is either the SP, who is the head of the district or the district subdivision, or maybe the commissioner, or the commissioner in commissionerate. Who is the police head of a district? If this is district A, district A, again, district A, okay? Head is the SP. SP is the head, superintendent of police. No one is above him. But now there is a difference. Now there are places where the commissionerate has been broken. Commissionerate has come. What are the commissionerates? For example, if this is a district A, it is impossible for one SP to split out the several districts. So there are police subdivisions in a district. Now, before 2010, there was hardly very little, almost not. But now, it is in West Bengal I'm talking about. There are commissionerates. For example, Barakpur has been cut down. This is suppose this is 24 PGS South, 24 PGS North. ठीक है? This is Barakpur commissionerate. ठीक है? Is head of the Barakpur commissionerate is the commissioner. Here is the Vidhannagar commissionerate. ठीक है? The rest will be looked after by the SP Shodor. Now there is SP1, SP2 in some districts. Bardhaman, Puro Bardhaman has divided into parts, SP1, SP2. It is impossible for one SP to look out the entire district. And people's redressal, people won't get any benefit. And thousands of people with complaints. It's possible for one person. So there are other police subdivisions as well. Calcutta is Calcutta South, DC North, DC South, DC Central. Commissionerates, it has been broken down the commissionerates. Okay? Very good. So, and in between there are several police stations. The OC, we call it when it is under the SP, but if it's a commissionerate area, we will call it the IC. It is nothing but just a mutual understanding. We call them the IC. Okay? So this is how it happens. Now, we will proceed. Police officers superior in rank 31. Public going to assist magistrates and police. Every person is bound to assist a magistrate or police officer reasonably demanding his aid. A. In the taking or preventing the escape of any other person whom such magistrate or police officer is authorized to arrest. Correct? Being a responsible citizen of the country, it is your duty. When a police will go for investigation, you have to aid. Otherwise, you will commit an offense under the Bharatiya Nyaya Samhita. In the taking or preventing the escape of any other person, a man who is to be arrested, he is running away. It is your duty to stop him, catch him, and hand him over to the police if police is chasing him. Or even if there is no police, you can still arrest. Every human being has a power to arrest. Even you can arrest a person on the road. But you have to pose him to the nearest police station. That we will read later. B. Or maybe that a man is escaping. You have to stop him from escape from custody. B. In the prevention or suppression of a breach of peace. If you think, being a responsible citizen, that there can be a breach of peace anywhere, it is your duty to make sure, to take initiative to see that there is no breach of peace. C. In the prevention of an injury attempted to be committed to any public property. When you destroy any public property, it is your duty to see to prevent it, that no public property, because it is the property of the country, the resources of the state. It is your duty to prevent it from being destroyed. 32. 80% other than police officer executing warrant. When a warrant is directed to a person other than a police officer, any other person may aid in the execution of such warrant if the person to whom the warrant is directed be near at hand and acting in the execution of the warrant. When a warrant is directed to a person other than a police officer, any other person may aid in the execution of such warrant if the person to whom the warrant is directed be near at hand and acting in the execution of the warrant. A warrant of arrest has been issued against a man. It will be directed to whom? The investigating officer of the case, that you are to execute this warrant, means arrest him and bring him back to me. Now he has come to execute the warrant. You are what are you? A responsible citizen. He can ask for your help, that I will arrest the man, kindly help me. You are bound to help him. Or on your own, you can extend your help to him. To help a public servant in the execution of a warrant. It is expected of you. You cannot run away. You can just say that I do not know anything. That will be a shaking of your responsibility. Should not. 33. Public to give information of certain offences. Every person aware of the commission of or of the intention of any other person to commit any offence punishable under any of the following sections of the Bharatiya Nyaya Samhita 2023, namely 103 to 105, both inclusive. So what are these sections all about? Every person aware of the commission of or of the intention of any other person to commit any offence punishable under any of the following sections of the Bharatiya Nyaya Samhita. What happens? Shall, in the absence of any reasonable excuse, the burden of proving which excuse shall lie upon the person so aware, forthwith give information to the nearest magistrate or the police officer of such commission or intention. Whenever you come to see or you come to know that such an offence has been committed or will be committed or an attempt has been made, it is your duty to forthwith give the information to the nearest magistrate or the police officer of such commission or intention. The nearest police station you have to inform. 2. For the purpose of this section, the term offence includes any act committed at any place out of India which would constitute an offence if committed in India. That we will read later on in section 108 or something like the BNS, 88 of the CRPC. That when are you in India and you commit an offence, and thereafter what happens? An offence is committed outside India. If you are a citizen of India, it will be deemed that you have committed the offence within the territory of India. If you commit an offence on a ship made in India, it will be considered, and if you have done the offence in Singapore or in the middle of an ocean, it will be considered that you have committed the offence in India, because the ship is nothing but an extended portion of the territory of India. Okay? Let's see that later on. 34. Duty of officers employed in connection with affairs of a village to make certain report. Every officer, this is okay. Every officer employed in the connection with the affairs of the village and every person residing in a village shall forthwith communicate to the nearest magistrate or to the officer in charge of the nearest police station, whichever is nearer, any information which he may possess respecting. Now, this magistrate includes an executive magistrate as well as a judicial magistrate. In the previous section also, in all the previous section also of this chapter, magistrate includes an executive magistrate or a judicial magistrate. Okay, both. It's always a judicial magistrate who comes before an executive magistrate. Is always a judicial magistrate because he can take cognizance of an offence. He can take cognizance. We learn what is cognizance is. We have not learned that. Okay. B. The resort to any place within or the passage through such village of any person whom he knows or reason to believe or reasonably suspects to be a robber, escaped convict, or proclaimed offender. The commission of or intention to commit in or near such village any non-bailable offence or any offence punishable under section 189 and section 191 of the Bharatiya Nyaya Sanhita. The occurrence in or near such village of any sudden or unnatural death or of any death under suspicious circumstances or the discovery in or near such village of any corpse or what is a corpse? Dead body, yes. In circumstances which lead to reasonable suspicion that such a death has occurred or disappearance from such village of any person, in circumstances which lead to a reasonable suspicion that a non-bailable offence has been committed in respect of such person. You find a person lying dead with injuries. It is nothing but a cognizable offence has taken place. It's your duty to inform immediately. The commission, any unnatural death you have to inform. Any unnatural death you come to know. The commission of or intention to commit at any place out of India near such village, any act which, if committed in India, would be an offence punishable under any of the following sections of the Bharatiya Nyaya Sanhita, namely clauses F and G of section 326, 331, and 332. So this is where the difference comes. The commission of or intention to commit at any place out of India near such village, any act. So it is very close to the Indian territory. You can still complain. Still inform. Any matter likely to affect the maintenance or order of the prevention of crime or the safety of persons or property, respecting which the district magistrate by general or special order made with the precious sanction of the state government. That's it. So these are the things that what this village includes. Includes village land. Proclaimed offender includes any person proclaimed as an offender by the court or authority in any territory in India. We will learn what is a proclaimed offender when we do proclamation attachment. The words officer employed in connection with the affairs of the village means a member of the panchayat. ठीक है सर? Functions and connected with the physical village. Now we will go to arrest of a person. What is an arrest? ठीक है? When police may arrest without warrant. When Be very careful from section 35. Any police officer may, without an order from a magistrate and without a warrant, arrest any person A who commits in the presence of a police officer a cognizable offence, against whom a reasonable complaint has been made, of credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offence, punishment with imprisonment for a term which may be less than 7 years, or which may extend to 7 years, whether with or without fine, or if the following conditions satisfy, namely. So what does section 35 says? Section 35 says first thing, that any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits in the presence of a police officer a cognizable offence. That is, who commits what? Can arrest without warrant. Without warrant, can arrest without warrant what? Or a person who commits a cognizable offence. Again, this is the most important part. Who commits a cognizable offence? Now, so on the first place, it has to be a cognizable. What is a cognizable offence? Are offences where a police has the power to arrest a person without a warrant. So there has to be an order from the magistrate. No order from the magistrate, no warrant with him. He can still arrest a person if that person has committed an offense which is cognizable in nature. Number B, against whom a reasonable complaint has been made, or capable information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, punishment with imprisonment for a term which may be less than 7 years, or which may extend to 7 years, whether with or without fine. So, number one, personal knowledge of the police. If yes, if there is personal knowledge of the police. Again, number two. We'll give bullets. It's better we'll give bullets. Again, personal knowledge of the police. Number B is that when he commits an offense, it can be less than 7 years, but it may extend up to 7 years. So, up to 7 years. Okay? Up to 7 years. Okay? Now we'll come to the next one. What conditions has to be satisfied in this case? The police officer has reason to believe, on the basis of such complaint, information, or suspicion, that such person has committed the said offense. This has to be believed. One minute. Personal knowledge of the police when he commits an offense up to 7 years. But that has to satisfy one. What is the satisfaction? When he receives a complaint, he goes to what? He goes to the complaint, He goes to the contents of complaint.
If he finds first and foremost thing is that there has to be a cognizable offense. Disclosure of a cognizable offense. Now, not only disclosure of a cognizable offense will allow you to do that. Most important part is that he has reason to believe that the man has committed the offense. He has reason to believe there has to be a reasonable suspicion that yes, he can commit the offense. What can happen? Suppose I am coming, I go to the Hastings police station. All of you go to the Hastings police station because all of you are adult. You have your sui juris, so you can lodge a complaint. You go to the Hastings police station and lodge a complaint that I was coming through the hospital road and I saw Victoria Memorial stolen. It does disclose the commission of the cognizable offense theft. But will the police set out for an investigation? No. Because he has to reasonably believe that the man has committed an offense if there is an allegation against a particular person or unknown miscreants. He has to believe that an offense has been committed. That the man has committed an offense is not that what important is that the offense has been committed. Victoria Memorial can be stolen. Cannot be enough. So there has to be a reasonable apprehension. Yes. You believe justice, satisfaction does the Lord. Suppose I go and say to the police that A has committed the offense at 6:15 at such and such place. The police was at a law and order duty at 6 o'clock at a place which is at least 7 kilometers away from the place of occurrence. Police says that till 6 p.m. I was at that place for law and order duty and I saw A at that place. He was in that meeting when I went for law and order duty. At 6 o'clock, it dispersed. The meeting ended, the crowd dispersed. And you are saying at 6:15 he has committed the offense at such and such place, which is 7 kilometers away. It is impossible for him to reach. But at 6:10. So that's a reasonable belief, a reasonable suspicion as to arouse that he might have committed the offense or he can have committed the offense. The only police will set out. Now, it's not that in 15 minutes he can't reach 7 kilometers. He may. If the roads are very clean, there is no traffic jam, he can go. So the police there has to be a satisfaction first, the initial private satisfaction. Okay? Number two, the police officer is satisfied that such arrest is necessary, A, to prevent such person from committing any further offense, or for proper investigation of the offense, or to prevent such person from causing the evidence of the offense to disappear. The first thing is that prima facie satisfaction. Prima facie satisfaction that an offense cognizable in nature, has been committed. Number two, arrest is necessary. One, to stop further offense. How can he stop further offense? He has committed a murder. He's fleeing away. People have seen him at place A, thereafter 1 kilometer later at place B, and anyone going to stop him, he may assert him. He may kill that person also, unless not immediately is arrested. Okay? Or if he is not arrested, he may hide what? The weapon of offense. Or the dead body. He can put the dead body at some place where the corpus delicti cannot be found. Where is corpus delicti will learn in Evidence Act. Number B, for proper investigation of the offense, and if he is not arrested, investigation cannot be done. Number two, custodial interrogation is necessary. Custodial interrogation is necessary. Now, you can. Okay. Custodial interrogation is necessary. Number C, to prevent such person from causing the evidence of the offense to disappear or tampering with such evidence in any manner. Number 3, stop tampering of evidence. Tampering of evidence. Evidence যাতে নষ্ট না করতে পারে, লোপাট না করতে পারে, ডিস্ট্রয় করতে পারে, কনসিল করতে পারে, অথবা so it can be evidence which includes concealment and destruction. ঠিক আছে? Concealment and destruction. Along with that, and also suborning of witnesses. That is one winning over a witness. Either he can be threatened that if you give evidence against me in the court, I will see you, or he may bribe him. It is winning over of an evidence. প্রমাণ নষ্ট করা যায় না, witness ko to tamper করে দিতে পারে যে সাক্ষী দিবি না আমার বিরুদ্ধে. It's very similar to that. So stop tampering of evidence, concealment and destruction, and also suborning of witness. Okay, I'm deleting this.
Suborning মানে bribe
Suborning of a witness to corrupt a witness, either by threatening him or by giving him money. Witness কে সেই বিষয়ের মধ্যে সাক্ষী না দেয়, কোর্টে না যায়, সেইটাকে বলা হয় suborning of witness. ঠিক আছে? Suborning of witnesses. Number E, as unless such person is arrested, his presence in court whenever required cannot be ensured. Number 4. He may evade the due process of law unless arrested. Today, as we know, he can be booked, he can be brought under the judicial surveillance, the umbrella of the court, unless he is arrested. Because no person will go to court unless he is taken to the court. Why will he go? After committing a heinous crime, why will he go? So, unless arrested, he may evade the due process of law. And the police officer shall record while making such arrest his reasons in writing, provided that a police officer shall, in all cases where the arrest of a person is not required under the provisions of this subsection, record the reason in writing for not making the arrest. C. Generally, if custodial interrogation is not necessary, he does not arrest. But it's absolutely the discretion of the investigating officer. No one can direct, neither not even the Supreme Court, that you arrest a person or you don't arrest a person. It's absolutely the discretion of the police officer. That is why during investigation, the police officer become so smart. You know that he has almost unfettered power, almost, against whom credible in writing for not making the arrest, or C. Against whom credible information has been received that he has committed a cognizable offence punishable with the imprisonment for a term which may extend to more than 7 years, whether with or without fine or with death, and the police officer shall have reason to believe on the basis of the information that such person has committed the said offence. So C and B, 35(1)(b) and 35(1)(c), 1C are same. What is written in C? 35(1)(c). In 35(1)(b), 1B, we have seen that it is up to 7 years. Take it? Up to 7 years. In 35(1)(c), we are finding that now it extends up to death. 35, section 35(1)(c). It extends up to death. It extends up to death. Up to death. ঠিক আছে? So there was a necessity of 31B. একবারে বলে দিতে পারতো that all offenses are extends up to death sentence. All cognizable offenses that extends up to the punishment of death sentence. ঠিক আছে?
That sir, cognizable offense আগে ছিল যে 7 up to 7 years. তাহলে
সিতে আবার বলছে যে আবার কখন কখন সে করতে পারে যখন সে credible information পাবে that it may that the offense that the cognizable offense that has been committed may extend to an offense that is punishable with death. Come on, from 0 to death, death is the maximum.
তাহলে
Now all offenses that which are cognizable in nature, so the একবারই বলে দিতে পারে
স্যার এক্সামের কি লিখবো 7 years লিখবো না up to date?
up to date. Up to date পরীক্ষা বলেই তো দিচ্ছি up to date. আমি এর মধ্যে বলছি D. The occurrence in or near such village of any sudden or unnatural death or of any death under suspicious circumstances or the discovery in or near such village of any corpse or part of a corpse in circumstances which lead to the reasonable suspicion that such a death has occurred or disappearance from such village of any person in circumstances which lead to a reasonable suspicion that a non-bailable offense has been committed in respect of such offense, such person. ঠিক আছে? Cognizable হতে হবে। The question is, now comes the second question, that arrest can be done now. First we have seen what? It has to be cognizable. Now what are we getting? We are getting number 2 after such analysis that it has to be a non-bailable offense. How can a police arrest in a bailable offense? Anna? Or non, it has to be a cognizable non-bailable. In a non-bailable offense, it means what? It's a in a bailable offense, he can arrest, but he has to immediately release him from the police station. ঠিক আছে? Okay. If who obstructs a police officer while in the execution of his duty or who has escaped or attempted to escape from lawful custody. আর কাদের কাদের করতে পারে? Then C, right? Yes, এবার D. এবার D. So D is, it is a proclaimed offender. Proclaimed money, maybe he has committed a bailable offense or a non-cognizable offense. Cognizable হতে পারে, non-cognizable হতে পারে। হ্যাঁ, but he is not coming to court day after day. Warrant has been issued against him and still he is not coming. তার against a proclamation বেরিয়ে গেছে। এটা আমরা কয়েকটা সেকশন পরেই করব, what is proclamation? ঠিক আছে? Proclamation so is a proclaimed offender. E, a person, a recipient of stolen property. ঠিক আছে? ঠিক আছে? theft হলে তো cognizable হয়ে গেল। তাই তুমি হচ্ছে চুজ করো। If not the theft, someone has called theft and given it to him. E, ABCDEF. Who obstructs the police officer while in execution of his duty. Obstructs whom? affects a police officer or a government servant that includes a government servant or who has attempted to flee from lawful custody. So if attempt is the offense, is punishable, you can arrest him. So commission will always be arrested. Even attempt is enough. Who is already in custody need not be arrested again if there is an attempt. But if he has flee away, then there has to be a second arrest. G. Who is reasonably suspected of being a deserter from any of the armed forces of the Union. G. Deserter of the armed forces. So this is very important. So these are this has to be by heart. This has to go by heart that when a police officer can arrest without a warrant. First, you have to give the conditions. It has to be a cognizable, non-bailable offense. Okay? And then 1, 2, 3, 4, you will write what should be the offense, quantum of offense. 7 years of the property in India. Any offense which is cognizable, non-bailable nature, which extends up to the punishment of death sentence.
Cognizable and non-cognizable.
Cognizable লিখবে শুধু cognizable হলে arrest without a warrant, non cognizable কি করে করবে? Non cognizable পারবে না, non cognizable পারবে না। Where there is a reasonable suspicion exists that he has committed an act outside India, which if committed in India would have been punishable as an offense, and for which he is under any law relating to extradition or otherwise. Yeah, he committed outside India, and has come within the territory of India. Not just committed outside India. Indian citizen. He has to be an Indian citizen. Indian citizen. That is mandatory. Because an Italian committing an offense in Singapore, India has nothing to do with that. Has India anything to do with that? An Italian committing an offense in Singapore? Or a Pakistani committing an offense in Iran, India has anything to do with that? Who being a released convict commits a breach of any rule made under Section 5 of Section 394. Breach of rule of Section 5, subclause 5, subsection of Section 395, subclause 5. ठीक है? 394, sorry. 394 subclause 5 of the BNAS. I. A requisition from another police station satisfying all conditions where a police can arrest without warrant. ঠিক আছে? Police can arrest without warrant. Suppose an offence has been committed at Baliganj. Baliganj police station is investigating. It has the power. If it is a cognizable non-relevant, it has the power to arrest a person. To arrest a person. Now he has flown into the another police station of Baliganj police station. A requisition has been made to the Baliganj police station that if you find, you arrest him. Because all the conditions of arresting him without a warrant is there. All police stations are nothing but an extended hand of Egypt. To arrest for anything. So, ultimately we have come to what? Now tell me, what do you think is a cognizable offence? In general, cognizable offence, the definition is that a police can arrest without a warrant. We know that. An offence that police can arrest without a warrant. What bell does it bring in your mind? That what type of offence it can be? A police can arrest without a warrant. Yeah, like the condition I said, you get the due process of law. Well, very good. Dacoit, rape, assault of such a nature that may cause serious injury, harm, or may kill or may lead a person to death, and many more. So what does it indicate? What are these types of offences? Which are brutal offences, which are grave offences. But how will you know from the 300 and above offences in the BNS and 511 offences in the Indian Penal Code, which one of them are grave or which one of them are not grave? How will you decipher? For you, date of a pen, one murder may be too much. For me, at least, unless there is 7 murders, there is nothing. What may be grave to you may not be grave to me. What may be grave to others? What may not be grave to you may be grave to others. Tell me, how will you know which? So many offences, so many offences. Which one is a cognizable offence and which is not a cognizable offence? I say, you say this is a very grave offence, arrest him without a warrant. I say this is not a very grave offence, I will not arrest him without a warrant. So according to you, it is a cognizable offence, according to me, it is not. There will be confusion. Accused will come and say, why did you arrest me? Well, who said this is a cognizable offence? Who said? And what will you do? There is a schedule at the end of the CRPC. No one can decide on his own. See, there is a schedule at the end of the CRPC. We call it the first schedule. The first schedule at the end of the CRPC. Fast call. This is the schedule. Come to the first page of the schedule, from where the schedule starts.
Trespassing cognizable offense এর মধ্যে পড়বে?
There will be no confusion. The first column is the section. The second column is the offense. All offenses are pertaining here to BNS. The next is what is the punishment for that offense? Cognizable or non-cognizable? So whichever offenses the CRPC denotes as cognizable, that has to be cognizable for each and every human being. And whichever CRPC says it is not cognizable, it is not cognizable. No one can change that. No person in this country can change it, not even a judge of the Supreme Court of India or the High Court judge. No one. No one can make it on his own. So that column is cognizable or non-cognizable. The next is whether that offense is a bailable or non-bailable. Like this may say it's a bailable offense, you will not be bailed. I will say no, it's a very grave offense, it is not bailable. No, CRPC will say which is bailable and which is not. The schedule. Whenever there is a doubt, we open the schedule and see whether the offense is bailable or non-bailable. Whether the offense is cognizable or non-cognizable. Okay? So number 6. By what court trial? If the accused is a charge sheet has been submitted against him, there is a police report. Which court he will be tried? Whether by a magistrate of the first class or the second class, whether by a sessions judge. There is no assistant sessions judge now. Or even High Court has a power for trial. We have seen that. High Court's power for trial. ঠিক আছে? So if anyone challenges you, well, there is no challenge. Just open the CRPC and see. The confusion will go. Okay? Now come to the end of this table. So these are all offenses of the Bharatiya Nyaya Sanhita. What happens if there is an offense committed by a person in a special act? There may be cognizable offenses there also. Complaint may come on that also. Police have to investigate on those cases of arms act. Or pocket. He has no papers to show license. Illegal possession of arms. That is a cognizable offense. That is bailable or non-bailable, maybe bailable or non-bailable. What happens? And police has to investigate, has to arrest. If it is mentioned that the offense is bailable in that act, it will be bailable. If it is mentioned that offense is non-bailable, which of the offenses are non-bailable in that act has many sections, many offenses. All may not be non-bailable. They may be bailable, may be non-bailable. Whichever is mentioned there will be bailable, and whichever is mentioned there will be non-bailable. Whichever is mentioned there as cognizable will be cognizable. Whichever is not mentioned there as non-cognizable will be non-cognizable. But if nothing is mentioned, whether cog or non-cog, whether bailable or non-bailable, what we will do? Whatever the procedure is not mentioned in the special act, what did we learn? CRPC will follow. The BNSS will follow. So come to the end of that table. We go to the second schedule. We go to the part 2 of the first schedule. Sorry. That was the part 1, which consists of the Indian Penal Code. Now come to the part 2. Classification of offences against other laws. Come to the last page of this table. Got it? Got the last page. You got this part 2. Classification of offences against other laws. If punishable with death, imprisonment for life, or imprisonment for more than 7 years, cognizable. In the first part of the first schedule, we have seen that the specific offences have been made, and what is the punishment as mentioned in BNS. Here there is no. Here there may be another 125 minor acts. It is possible for all the act to be written in a table. So there is a general classification as far as other acts are concerned. If punishment with death, imprisonment for life, or imprisonment for more than 7 years, cognizable and non-bailable. If punishment with imprisonment for 3 years and more, 3 years and more upwards, but not less than 7, মানে 3 থেকে 7 এর মধ্যে যদি হয়, মানে 3.1 থেকে 7 এর মধ্যে যদি হয়, তাহলে it's cognizable, non-bailable, magistrate of the first class. If punishment with imprisonment for less than 3 years or with fine, it is non-cognizable, bailable, any magistrate. Okay? Clear? We'll come back to arrest again. So you know which offense under the Indian law, all the offenses of all the acts, which one is cognizable, which is not cognizable. From today you know it. ঠিক আছে? যখন এভাবে তুলে দেখে নিতে হবে। এটা শিডিউলটা। ঠিক আছে? ঠিক।
এই চ্যাপ্টার কি বললো যে ইন্ডিয়ার বলে কমিটেড আউটসাইড ইন্ডিয়া যেটা ইন্ডিয়ার সিটিজেনরা তেমন বাইরের কোনো কিছু থাকে হ্যাঁ এইচ প্যারাগ্রাফ বুঝেছো না যে বলছেন মানে ওই কমিটেড আউটসাইড
ওকে আপনি ভারতের ন্যায় সংহিতা ওপেন Open 394.
of the Nagarik.
BNSS.
BNSS, sir. Reads subsection 1 of 394. Read subsection 1. You understood?
যদি দুবার ধরে পানিশমেন্ট দেওয়া হয় একটা
There is a second time punishment and he is released on bail, then he has to notify his address. So this order can be made by a session court by any appellate court also. When there is a second punishment and he is released on bail, in the same punishment he has to notify his address to the
court.
When any person having been convicted by a court in India of an offence punishable with imprisonment for a term of 3 years or upwards, or is again convicted take I'm like is again for one second conviction of any offence punishable with imprisonment for a term of 3 years or upwards. 3 years, because 3 years stay I'm like by any court other than that of a magistrate of the second class. Such court may, if it thinks fit, at the time of passing a sentence of imprisonment or such person, also order that his residence and any change of or absence after release be notified as hereinafter provided for a term not exceeding 5 years. Hearing provided by a term the extension of sentence. An order under this section may also be made by an appellate court or by a high court or a court of session when exercising the powers of revision. Last single line underline quoted in 94(1). Also order that his residence also the game.
Not exceeding 5 years.
Also order that his residence and any change of or absence from such residence after release be notified as hereinafter provided for a term not exceeding 5 years from the date of the expiration of such sentence. H, yeah?
So, মানে H মানে কিন্তু হচ্ছে ওটা committed outside India আপনি double বার G হয়ে গেছে G লিখে দিয়েছি Gটা
Sorry. I তো তুমি এখানে না দেখছি ঠিক আছে first conviction 3 years or upwards. ঠিক আছে? No, sorry, 3 years or upwards. ঠিক আছে? 3 years or upwards. ঠিক আছে? 3 এর নিচে যাব না। Second conviction. 3 years and upwards. Second conviction যখন রিলিজ হবে, খাটা হয়ে যাবে, যেদিন আপনি রিলিজ করে দিলেন সেদিন থেকে 5 বছর। Date of release to 5 years. He has to inform the authorities regarding his actions when he is deciding and when he is not outside the station. Till to 5 years, he is addressed. Now he is a habitual criminal now. That knowledge of the drug, his address and any release, any absence. হঠাৎ সে থাকে এখানে থাকে, হঠাৎ সে গায়েব, অনেক দিনের জন্য কোথায় গেল, আবার কি ফোন দিয়ে আসছে, জানি যেতে হবে, আমি এই কারণে আমার দিদির বাড়ি যাচ্ছি মধ্যপ্রদেশে, আমি আউট অফ ইন্ডিয়া যাচ্ছি, আমেরিকা যাচ্ছি ঘুরতে, তাই না? ক্লিয়ার? ওগুলো দেখো জানতে। After his release, be notified as hearing and provided for a term not exceeding 5 years from the date of the expiration of such sentence. Didn't expire করবে, রিলিজ হবে। এই হকই didn't expire করবে, সেদিন তাকে রিলিজ করে দেবে, একদিনের বেশি তার জেল থাকার কথা না। অনেক সময় কি হয়, ছাড়তে পরের দিন হয়ে যায়। অনেক জেলের অনেক নিয়ম থাকে, বিকেল 5টা করে ছাড়বো না, রাত 12টার দিয়ে শাস্তি চলবে। কি হয়, যেদিন শেষ হয় তার পরের দিন অ্যাকচুয়ালি ছাড় রাত্রি 12টার সময় শেষ হচ্ছে, রাত্রি 12টা একে তো ছাড়তে হবে না, মাঝে তো জেল থেকে কাউকে ছাড়া হয় না, জেলের অনেক নিয়ম কানুন আছে। পরের দিন সকাল 10টা না বাজে কোনো রিলিজ হবে না, পরের দিন সকাল 10টা অবধি তো সে থাকে, ওইটুকু সময় এক্সট্রা জেল থাকে। ঠিক আছে? Now we will see section 2. Subject to the provisions of section 39, no person concerned in a non-cognizable offence or against whom a complaint has been made or credible information received or reasonable suspicion exists of his having so concerned shall be arrested except under a warrant or an order. Now we will come to clear? Clear? Section 35(1)(c). Now we will see 2. Non-cognizable offence. A non-cognizable offence can be what? A non-bailable offence? Bailable offence তো arrest কোনো ব্যাপারই নেই পুলিশে, bailable offence তো। If it is a non-cognizable and non-bailable, then only he can be arrested. But police cannot arrest without a warrant. Without a warrant. খুবই সামান্য সেকশন আছে কয়েকটা, which are non-cognizable and non-bailable. Basically, non-cognizable is bailable offences. So it cannot arrest without a warrant of arrest. And a warrant of arrest issued by the court ছাড়া, warrant of arrest issued by a magistrate, a judicial magistrate, ঠিক আছে, cannot arrest without a warrant. And read subsection 2 once again. Subject to the provisions of section 39, no person concerned in a non-cognizable offence or against whom a complaint has been made or credible information has been received or reasonable suspicion exists of his having so concerned shall be arrested except under a warrant or order of a magistrate. ठीक है? Warrant or order of a magistrate. 3. The police officer shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. Now, this is very, very important. 25(3). Very, very important. Okay. Now we will see 35(3). Very important. 35(3). I have to tell you a story now. Cognizable and non-cognizable offenses are being committed all over. And day after day, what is happening? Day after day, what is happening? That in many cases, a person gets arrested who later on be found to have committed offenses which are unfounded. Okay? Day after day, people are being arrested. Huh? Day after day, people are being arrested. What happens? A man is getting arrested, he is sitting with his family, or he is doing his job, suddenly he comes and arrests him. Later on, he is found what? The allegations were founded on Mara Fide. But by that time, people in Kolkata have seen police coming in, taking him up to the police vehicle and taking him to the police station. His reputation goes, he is defamed, his family is in agony, trauma, his children are in trauma. This has been going on. Time and again, the Supreme Court has been knocked to get an answer, but there was no answer. There was never an answer. Supreme Court tried it in 1945 when there was Privy Council. This was sort of, there was no answer in Awaz and Nazir's case. Then Article 1920. Then 1990, Badenlal. Then there have been several cases where there was said that there has to be an answer. Because there were too much misuse and people are for just personal vendetta, lodging cases and getting people arrested. Arrest of a person is a dangerous thing. One day you are arrested and kept in police custody. You are mental agony. And the pain and your defamation, reputation, everything goes. For what reason I will be in custody? Why police arrest me? I have done nothing. But there was no answer. So in Rajinder Singh Kanach's case in 2007, the Supreme Court said that we allow the police to do a preliminary inquiry. Reason to suspect. Prior to satisfaction, police do a preliminary inquiry for 1 or 2 days, and then police come up and arrest him. But in 1 or 2 days, what does the police can do in a preliminary inquiry? Know that an offense has been committed or not, or who might have committed. Later on, if there is no evidence, or if it comes out in this station that is unfounded allegation, what will you do? Then came Lalita Kumari 2013. Supreme Court gave a little more. I'll give you. The Supreme Court gave a little more indulgence to the police officers. 2013. Lalita Kumari. Police officers said yes. If it is, you can go for the preliminary inquiry also, you can go up to the spot. Next time to the spot, you can see it and then you can come back. Because when an FIR is lost, there has to be an investigation manager. So we could allow. But still, there was no answer. People were getting arrested. Then came 2014 for the first time in 65 years of Supreme Court. Shekhar and look at Shekhar Nathani. He gave a proposal to the Supreme Court. What was the proposal? Let us do one thing. What is the answer? That please give a notice to the person whom we will arrest. And let that person be aware that a criminal case has been filed against him. He can either go to the court and take a surrender and take the bail, or he may have a chance to go for anticipatory bail, or he may have what? A chance to defend himself somehow or the other. There was a counter argument that he may flee away the moment he will know that there criminal case is filed against him. He may tamper evidence the moment he knows that police has come to know and affair has been lodged. He may tamper evidence. He may flee away. He may evade the due process of law. What to do? Then Sheikh al-Nafar is said. Because let us first read the section, then I will say what Sheikh al-Nafar is. The police officer shall in all cases, but the arrest of a person is not required under subsection 1. Issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense until it is cognizable. So it is talking about cognizable offense. Okay? A police officer কি করতে পারে? When he feels that an arrest is not necessary, that discretion, when he feels that an arrest is not necessary, what he can do in a cognizable offense? Issue a notice directing the person underline the word shall. The police officer shall. শুধু shall টাকে underline করো, ঠিক আছে? তাহলে shall cognizable offense. কি করবে police officer? Is not required. Issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense to appear before him at such time and place, or such other place as may be specified in the notice. তুমি আমার কাছে appear করো, আমি তোমাকে but for what purpose is asking to appear? For the purpose of interrogation. Has to be. So it has said that the police officer shall in all cases. Now, all cases means where the punishment from 1 year to death penalty, or even below than that from 0 to death penalty. In all cases, and he shall. In every case, he will say that I need him for the purpose of custodial interrogation. I need him for the without arresting him, I cannot investigate. So it's the discretion of the police officer. Police officer shall in all cases where arrest is not required. Who will decide whether arrest is required or not? The police officer himself, who is the investigating officer, he will say in all cases I want him. He will arrest in all the cases. That is when a criminal case is FIR is lodged. The cognizable offense, police at the law cannot take it. Like how that now. Yeah? Sheikh al-Nafar said, it is all in order to stop this menace of this police arrest and malafide complaints lodging one after another, only to take revenge, personal vendetta, false cases. Let us make one thing. What is that? All offenses whose punishment is up to 7 years. They didn't give any mandatory. This officer in discretion that at all. It shows the offense. Whether it is up to 7 years, it is mandatory that he has to give notice. He cannot decide. Mandatory. Whether he wants him for custodial interrogation, whether he do not want for custodial, immaterial. Up to 7 years, he has to give notice. Any offense's punishment is 7 years, above 7 years. Above 7 years, it is his discretion whether he shall give the. Then came the judgment, the landmark judgment of Arnesh Kumar versus State of Bihar, 2014 Supreme Court. Arnesh Kumar versus State of Bihar. This is one judgment for the first time in the history of Indian judicial system has changed the entire structure of the country, has changed the entire equilibrium of the country, has changed the entire process of criminal investigation, and saved several of persons from being public humiliation of false cases. Brilliant. Arnesh Kumar, State of Bihar, 2014 Supreme Court. 2014 Supreme Court. Okay? This is the judgment that the Supreme Court has given 7 guidelines, which will come in your exam. It will be given to you by a slide on the next class. Okay? We will give you the slide. Arnesh Kumar was the State of Bihar. So, in Arnesh Kumar was the State of Bihar, the Supreme Court said that it is mandatory in all cases where the offense maximum punishment is up to 7 years, you have to arrest without a warrant. you have to send a notice. Now what happens? In the same case, it has been laid down by the Supreme Court of the Supreme Court that if a police officer may arrest a person. Now, Supreme Court has given a rider to that judgment. What is the rider? A police officer, an investigating officer may arrest without warrant in a cognizable offense. An IRO may arrest without warrant in a cognizable offense. May arrest without warrant in a cognizable offense. In a case where the punishment is maximum 7 years. On extraneous circumstances, if there is no time to give notice, or else there will be evading of due process of law, or evading of due process of law or tampering of evidence. Someone gave the information to the police station that yes, an FIR was lodged. He going to the FIR, he thinks that yes, going to the tampering of the evidence, ठीक है जी? Tampering of evidence. Of evidence, ठीक है जी? Huh? Very good. Now, suppose a council offence has been listed, maximum punishment is 7 years. Only 2 crores of rupees. Suppose the government will put up in I'll give him notice, mandatory notice. Notice to tomorrow I issue the notice for him to meet me on Thursday. Suppose on Tuesday and Thursday. Someone comes and gives the information that he's fleeing the country because he knows that once he's caught or he's in the area, he can never escape. 7 years he has to get to the jail. He's fleeing the country. Notice the arrest and detailed report for a couple of magistrate can 7 years or horse up to. Despite being the offense maximum punishment is 7 years, why did you arrest him without our notice? Without notice under 35(3), why did you? Or maybe that he is destroying such evidence that unless he is arrested, that destruction of evidence cannot be prevented. A detailed report has to be sent. Then and then only, otherwise the police officer will commit what contempt of the Supreme Court of India. It is there in the judgment and is liable to be suspension or disciplinary proceeding against him. The Supreme Court has said. Here, come to 35(4). Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. Otherwise, it will be disobeying a government servant. Together? 5. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice unless for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. Together? So when he goes to the police station, upon receiving a notice under 35(3) of the BNS, and the police calls him for what purpose? For the purpose of interrogation. After interrogation, if the police thinks that I need to arrest him at any time, the police officer now can arrest him. All of a sudden, he was not arrested. He was given enough time for reflection of mind. Notice came to him. He came on that day. After interrogation, the police officer thinks no, this investigation cannot be done without arresting him. He can at any point of time. The first day he did not arrest. He goes back home. He calls again he come on Friday for the interrogation. The second day he thinks that now, after interrogating him for 2, 3, 4 days, now such a situation is reached that the police officer thinks so many things are behind it. He has to honor this thing. Without arresting him, how can I honor? He now arrests him at any day, any point of time during interrogation. He can now arrest a person. Okay? 6. Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice. It is, of course, obviously the police officer is giving you notice for interrogation and day after day you are not going. Obviously, he will arrest you now. 7. No arrest shall be made without prior permission of an officer, not below the rank of deputy superintendent of police, in case of an offence which is punishable for imprisonment of less than 3 years, and such person is infirm or is above 60 years of age. That is in this slide. In case of an offence punishable for less than 3 years and where a person is infirm or above 60 years of age, an arrest can be made only if the officer not below the rank of a deputy superintendent of police grants prior permission for such an arrest. So, a senior citizen gets a chance. A senior citizen gets a chance to prevent himself from the arrest by taking still goes to law, because
he gets time. Infirm or above 60 years of age, an arrest can be made only if an officer not below the rank of a deputy to the superior police. See the slide, slide. An officer not below the rank of the deputy superior of police grants permission of such arrest. Okay? Very good. It's there at 7. This is section 35(7). Okay? We'll stop here today. Otherwise, they go through too much. Okay. So that everything can be put into your mind. You have to study at home. Several things are there. You have to, which you have to make by heart, you have to by heart. If you don't, which have to be understood, it has to be understood. If you don't understand, tell me on the next. Okay? Now we go.